Hello everyone, I'm Denise Garman, one of the senior HR consultants here at Hubric Resources. I want to share with you today an overview of a new law that goes into effect later this month on June 27th, the Pregnant Workers Fairness Act, or PWFA. If you're an organization that employs 15 or more employees, this law applies to you. The focal point of the PWFA is a reasonable accommodation for employees experiencing pregnancy, childbirth, or other related medical conditions. It requires reasonable accommodation for employees and applicants who can perform the essential functions of the job with or without reasonable accommodation. Essentially, this new law requires employers to treat pregnancy no different than a disabled employee needing a reasonable accommodation. And in fact, the definition of reasonable accommodation mirrors that of the ADA, or the Americans with Disabilities Act. Existing laws that the EEOC, the Equal Employment Opportunity Commission, enforces, such as Title VII and the ADA, make it illegal to terminate or otherwise discriminate against workers based on pregnancy, childbirth, or related medical conditions. The PWFA does not replace these federal laws or any state or local law that are more protective of workers affected by pregnancy, childbirth, or a related medical condition. More than 30 states and cities have laws that provide accommodation for pregnant workers. And Pennsylvania does have state-level employment protections against pregnancy discrimination and provisions for pregnancy accommodation. Under the PWFA, reasonable accommodation could include things such as light duty, more frequent restroom breaks, the ability to park closer to the building, or lifting restrictions. Like the ADA, what is reasonable accommodation is very fact-specific, and it is important to consider the employee's working conditions and the essential functions of the job. Regardless, the employee must still be able to perform the essential functions of the job with an accommodation. In addition, the undue hardship analysis still exists, which allows employers to decline a reasonable accommodation where significant difficulty or expense would be involved. And finally, similar to the ADA, under the PWFA, there are certain things employers are not permitted to do. Employers cannot require that a pregnant employee take leave, whether paid or unpaid, if a reasonable accommodation can be provided, which would keep the employee actively working and performing the essential functions of the job. Employers cannot require that an employee accept an accommodation without a discussion about the accommodation between the worker and the employer. This is known as the interactive process. Employers cannot deny a job or other employment opportunities to a qualified employee or applicant based on the person's need for an accommodation. And employers cannot retaliate against an individual for reporting or opposing unlawful discrimination under the PWFA, participating in a PWFA proceeding such as an investigation, or interfering with any individual's rights under the PWFA. The EEOC will start to accept charges under the PWFA on June 27, 2023. However, for the PWFA to apply, situations complained about in the charge must have happened after June 27th. And keep in mind that a pregnant worker who needs an accommodation before June 27th may have a right to receive accommodation under another federal law like Title VII or the ADA. Thank you for taking time to watch our video blog today. I hope you found this information helpful, and if you need more guidance or support implementing this new law in your workplace, please contact one of us at Hubric Resources. I'd also like to invite you to follow and like our page on Facebook, Instagram, and LinkedIn. Thank you and have a great day.